Hello, everyone. My name is Sarah Carmody. There's my contact information if you have any questions or concerns about what I'm about to say here. I will try to get through most of the beginning of this pretty quickly because I think we all know what's going on as far as the court makeup, and then we can get to your questions. So the first, and excuse me, I don't really know how to use PowerPoint. Article 3 of the U.S. Constitution is what sets up the judiciary. The founders only set up the Supreme Court and have allowed for lower courts. So any of the lower courts we have today have been made through acts of Congress and deciding that court sizes have gotten too big, the dockets are too large, we need more going on. So the setup as today is we have our federal district courts at the trial level, the U.S. Circuit Court of Appeals, and then the United States Supreme Court. So the federal district court of appeals comes first. This is the trial court level. There are 94 district courts in all 50 states, D.C., the territories. There we go. Divided into 12 circuits. This fun little map shows you where the circuits are. You will not see a number 12 because that is only located in D.C. and it's not big enough for this map. But there are actually 13 courts in this 13 circuits. So here's where all the major fun happens. You're going to get one judge and possibly a jury, depending on your case. And everything that you want any appellate court to hear needs to be heard at the district court level. Getting new evidence or new arguments in is a Herculean task. So you want to have a good attorney at this level that knows what they're doing. Kansas is in the 10th Judicial Circuit. Missouri is in the 8th. Just to let you know, the current nominee to the Supreme Court does come out of the 10th Judicial Circuit. So he has had some effect over the laws that you are currently living under. To get into the federal court, it's a little bit more difficult than some people make it sound. You do need what's called standing, and that's you are actually being hurt by some kind of federal law. That doesn't have to be that you're actually injured. It could be a financial injury, any kind of distinction that you are being treated differently because of this federal law. If you cannot find a reason that you are being hurt by this federal law, you're probably going to need to go to state court. So we need what's called a case in controversy in federal court. You have an actual person who's actually being harmed. They don't take hypothetical cases. This is true in the state court as well. The state court is set up the same as the federal level. You have your lower courts, appellate courts, and the Supreme Court, and you do need to have an actual person with an actual harm. Now, I know that there is a case pending right now that we don't have actual harm in quite yet, but we'll get to that. So you don't like your ruling at the federal district court level, you are going to appeal it. At this point, we're mainly talking about civil law. And if you're in federal criminal law and as a defendant you've won, the prosecution can't particularly appeal. But we're not going to go there. It's a 15-minute presentation. So you can appeal, the plaintiff can appeal, the defendant can appeal, both sides can appeal. The U.S. Circuit Court of Appeals, we hear appeals from the district court level, and then any federal agency, which also has their own internal processes. Here we get a 3-judge panel. There's no jury. There can be oral arguments, but they do not rehear a case. So attorneys write what are called briefs, which are anything but brief if you've ever seen one. They're very long. And then the court will convene a 3-judge panel. Typically it's a 3-judge panel. And either decide the outcome based on what the lawyers have written, or they will ask for oral, or they'll allow oral arguments. There are only two grounds for appeal, really. That's an error of law or an error of procedure. You're going to want an error of procedure if you're going to have a better chance of winning. Laws are very deferential to the lower courts. So then the appellate court only has three outcomes. And I'm sorry, I didn't realize that was so small. The appellate court can affirm or agree with the district court. They can reverse, disagree with the lower court, and they can remand back to the lower court. A lot of times you're going to hear reverse and remand, which means the appellate court has said this one area was decided using the wrong law. Go back and fix it, district court. Now, to be clear, you're going to go in front of the same district court and the same district judge that you had in the first case. So making arguments about how your judge was terrible is probably not going to help you when you get remanded, which people should probably think about. So this is also a loop that you can get stuck in for a while. You're at the district court level, you go to the Court of Appeals, they send it back down, have a new hearing on the appellate court part. The loser doesn't like it again, appeals it again, brings it back down. You can get stuck in this loop for a little bit. So if we actually make it out of that loop, you can get to the Supreme Court. This is the only picture I could find of the Supreme Court. We don't have a current picture of our current Supreme Court here. The acronym is SCOUTUS. If you use all of the letters, that's where you'll find it. There are 9 justices, although the Constitution is silent on the number of justices. There used to be 6. In the 40s, they tried to put a lot more on there. There are currently 8. This man here is Justice Scalia. He died over a year ago, and his position has not been filled. This woman on the very end is the best Supreme Court justice, in my opinion. Which is how you know I'm a nerd. I have a favorite Supreme Court justice. I've also taught my daughter to like her. So how you get here is much more difficult than anybody wants to make it sound. So there is a very limited set of circumstances where the Supreme Court can hear a case the first time it's being presented, which I'm not going to talk about. The main way that you get there is to go through the district court level, the circuit court level, and then you apply to the Supreme Court. You say, would you please hear my case? There are over 7,000 cases that apply to be heard in front of the Supreme Court every year. The Supreme Court will hear about 80 of those in oral arguments, and they will decide another 50 just based on their briefs alone. Everybody else is shut out, not getting in. Now, the way they actually decide which cases to hear is a little interesting. So all 9 or 8 justices right now go into a room. They do not have their clerks. They don't have anybody else, and they read through the applications, and you need 4 of them to say, I want to hear this case. And if you get 4 of them to agree to hear the case, then the case will be heard. It makes it much more difficult when you only have 8 justices, because now we need half of them rather than a little less than half. I'm not good at math. So the Supreme Court is much like any other appellate court. They only have the 3 options: affirm, reverse, and then you can remand it back to a lower court. If they affirm, there you go, you just made law. If they reverse, the lower court is going to have to go back and fix whatever the Supreme Court has found to be the issue. Okay. So what I think you want to know about today's political climate, the first is judicial review, which I don't think you know you want to know, but you do. So judicial review is something that everybody believes is in the Constitution, but it's not. It's the concept that the courts can review laws, orders, treaties, executive orders. The founders were actually in disagreement about this. They weren't sure if the court should be able to check the executive branch, There were lots of letters going back and forth. So the Supreme Court went ahead and decided on their own in 1803 that, yes, they did in fact have that power. It's in a very famous case, Marbury versus Madison. And once they decided that, who could review it? Nobody. So they, I think, are the most powerful branch of the government, but I know people are probably not in agreement on that. So the next one is the distinction between a temporary restraining order and a preliminary injunction. Oh my gosh, that went by really fast. Okay, these are really actually two different things, even though people use them interchangeably. They both effectively do the same thing, which is to prevent a law or action from occurring before it goes into effect. Okay, let's move on here. So why I think you're really here is the Immigration Executive Order timeline. I won't go through it with you because it's right up there. But effectively, the first Immigration Executive Order was signed and went into effect immediately. The first U.S. District Court in Washington, the first U.S. District Court to make a decision on it was in Washington, and they issued a national TRO. Now, the reason they can issue a national TRO, not just one for their circuit, is because we're dealing with an actual, constitutional right, which would be the freedom of religion. So if it's just a lesser right, they can only enjoin their circuit. But since we're talking about a right given to everybody in the United States, they can issue a national TRO. So this was appealed. TROs are not necessarily appealable automatically, but the Ninth Circuit allowed the appeal. They heard it, unanimously upheld the TRO. So almost a month later, the president signs the second executive order, does away with the first one, and then almost immediately it gets back into court. Hawaii, which is also in the Ninth Circuit, issued a national TRO, and Maryland has also issued a national TRO. At this point, the government has not taken it any further, so it is unclear where we are going with that, if we're just going to hear the cases or if they're going to try to move get the TROs to be struck down. Okay. Well, that is wonderful. So, I'm sorry. The fourth is allowing them to move forward. It actually is helpful. I'm sorry? Okay. It's actually helpful to have disagreements in between the circuits. It will help you get to the Supreme Court a little bit easier. If you have the disagreements rather than everybody agreeing that a law is against the Constitution. So I have this here just because more of pet peeves for me, legal words I think you might be using incorrectly. Perjury. Perjury is the willful telling of an untruth to an official proceeding. You can lie on Fox News all you want. It is not perjury. You cannot lie to the Senate after you have been put under oath. Okay? You can be charged for it. So treason, this is a word that's getting tossed around a lot lately. So treason, according to the United States Constitution, a person is guilty of treason if he or she is in war against the United States or gives aid and comfort to an enemy. This is actually the only crime that is specified in the Constitution, not in the amendments, but in the Constitution. And then we get down to our why people hate attorneys. So what is aid and comfort? What is an enemy? Who is an enemy? How is an enemy defined? And these are all questions that we're going to have to parse out and figure out before we can really start turning this treason word into something we need to start throwing out as accusations. 1 minute. Okay, so impeachment, we've kind of covered this with everyone else. This is a process rather than being a crime. And then this is my personal pet peeve. If you notarize a document, that does not make it legal. Just FYI, tell all your friends. Okay. All right. Any questions? Yeah. Mm-hmm. So the question was, the perjury definition was lying in an official proceeding. And yes, it would be under oath. Usually in an official proceeding, you would be put under oath. So in court, in front of Congress, things like that. Although there is a little tweak here, you're not allowed to lie to the FBI, which is, or on your tax return. Well, you sign under penalty of perjury on your taxes as well. So, any other questions? I know that went fast. Yes? Mm-hmm. Uh-huh. Right. Okay, so it's this Kansas-specific school funding question. For all those playing along here, so the Supreme Court has issued 2 rulings in Kansas over the last few years. One was adequacy, and the other one was equity. Thank you. My brain just turned off there for a minute. The Supreme Court cannot tell the legislature what to do. They can only tell them what they're doing wrong. So they have told the legislature that you are not funding your schools adequately. You're not funding your schools equitably. Fix it. And that's all they can do. If they put a dollar amount on it, they have overstepped their authority. So that is definitely a problem in Kansas right now that we're struggling with. The legislature did know for at least the last 2 years that this was going to be a problem, and they have chosen to ignore it. So I would assume that we have some severe budget cuts coming up, probably more taxes. If they would close that handy-dandy loophole, we would have a lot of money, but even that would not fund the schools adequately at this point. Okay? Anybody else? Oh, one more. Mm-hmm. Okay, so the question is more about ICE, the Immigration Customs Enforcement, and how they can continue to do their job with these executive orders. Again, this really isn't part of the judicial branch. This is more of an executive legislature. Well, right. Okay. So the judicial branch used his ruled the executive order unconstitutional for the moment. It's not saying they actually didn't rule it unconstitutional. They have said that it's on a temporary basis. This is not going to be in effect. So ICE is a branch of one of the areas that Christine was talking about. Christine was talking about. They have their own agenda. They have their own ability to do what their regulations state they can do. The judicial branch really can't get involved unless somebody challenges that. So at this point, if a school says, no, you can't come in, and then the federal government says, yes, we can, and there's a legal challenge, we will get to hear what the courts say. But at this point, nobody has challenged their authority to the point where it's gotten into the federal courts yet. Okay? The question was Kansas schools recently. Yes, Shawnee Mission came out and said that they will allow ICE officials to come into their schools without a warrant. And then other Kansas schools have said, no, they will not allow that. Okay, last question. Mm-hmm. Mm-hmm. I have read the same thing. That is definitely a question of law that needs to be interpreted, and Jerry Merrill is going to talk to us about our Fourth Amendment rights here coming up in a minute. Okay?